Thank you all for your remarks. We'll start our questioning with Mr. Cooper for 6 minutes, please.
Thank you very much, Mr. Chair. I will direct my questions to the public safety officials. How long will it take to implement the Foreign Influence Registry upon Bill C-70 receiving royal assent?
So thank you, Chair, for that question. It's something that is currently before Parliament, and we're going to see where it goes before Parliament. It is going to be a priority for us to set up the office based on the legislation if and when it is adopted to Parliament. We do recognize that there's significant interest in making sure that it is up and running before the next federal election. It is going to be a priority for us to set it up. There are numerous pieces of work that need to be done in terms of bringing in regulation to support implementation of the Act that will need to be done before we can actually bring it into force. It'll be up to the Governor and Council to determine when that coming into force is.
Well, thank you for that. Through you, Mr. Chair, there is regulation that needs to be set out, as well as setting up the commissioner who's going to oversee the registry. And so would it be fair to say it would take a number of months? Because my understanding, at least from the technical briefing, was that it may in fact take up to a year. Am I correct?
It could take up into a year. Not to get too much into the weeds in terms of bringing in regulations. There's a process for regulation, as the chair is aware. There's also a need in the legislation. The Commissioner for Transparency would be obligated to publish a registry to make known individuals who have registered. There is going to be a need to stand up the system so that people can register and that the Commissioner can then publish that registry online to make that information available. And so during the technical briefing, we did indicate that a year is what we're working towards and is the goal that we will attempt to meet.
Well, thank you very much for that. And there is clearly a lot of work to be done. And when I look at the calendar, it's May 30th, and there's only a few more weeks left before the House rises for the summer. And so looking at the next election, that's October of 2025. That's about a year away right now, having regard for the fact that we only have a few sitting weeks. And so this is just, this underscores a real concern that I have that this will not be in place in time for the next election. And it's as a result of a government that has dragged its feet, dragged kicking and screaming to finally introduce a foreign influence registry, despite calls for years by security experts, by diaspora communities, by conservatives. Indeed, it is, I would submit, not a coincidence that this legislation was introduced the day after the first sitting day after the damning report of Madam Justice Hogue, a damning report, an indictment of the government, an indictment of the Prime Minister. This is nothing more than an attempt by this government to use this bill for political cover in the face of conclusions that demonstrate that that we have a Prime Minister who turned a blind eye to foreign interference. And I have to say, the delay is unacceptable because consultations for a foreign influence registry ended 1 year ago. And therefore, had the government introduced legislation a year ago, we would have a foreign influence registry in place well ahead of the next election. But because these Liberals have delayed and failed to act, here we are with the very real possibility that we won't have a foreign influence registry in place. And if there is one in place, it will be right at the time that the election is called, which raises questions about its effectiveness during the campaign period. And given the timeline that we have. It is why Conservatives believe that it is absolutely imperative that we move this legislation forward quickly. It's why my colleague, Mr. Chong, the member for Wellington-Halton Hills, introduced a motion yesterday in the House of Commons to see that this bill would pass through all legislative stages in the House by June the 12th. But incredibly, yesterday in the House, the government's coalition partner, the NDP, blocked Mr. Chong's motion. And so here we have the coalition partner of the Liberals who've dragged their feet for years, who are now obstructing moving this bill through Parliament. And I can't help wonder why that is. It certainly demonstrates that Jagmeet Singh, once again, is an unserious leader, having regard for the fact that he doesn't see the need to move this along. And it raises questions about whether the NDP is doing the government's dirty work.
Follow the rules. You're new to the committee. Follow the rules, please. You follow the rules. You are right.
Thank you, Mr. Cooper. We're going now to, we'll start our second round now. We'll go right now to Mr. Caputo. 5 minutes, please.
Thank you very much, Chair, and I'm very grateful to have the expertise around the table that we have, and I thank all the witnesses for being here. I generally don't put my questions to one person in particular because I know that there's a lot of overlapping expertise here. So please, among you, just feel free to chime in if you feel like you have a good answer to the question. My first line of inquiry looks at what we've colloquially called the Foreign Influence Registry. When it comes to that, what would be the minimum amount of time that it would take to set something like this up, and perhaps even just what would be estimated? I think 1 year was kind of thrown around, but I'd like to get to a bit more of a solid answer, if I could, please.
Thank you, Chair, for that question. A year is what we are estimating currently it would take to set up the registry, and that's taking into account, just to get into some level of detail, regulations that are required to launch the operation of the regime. There are some pieces of regulation that are necessary to do that. There's for example, the information that must be provided to the commissioner by a registrant, and then the information the commissioner shall make available on a registry. So just to give 2 examples, there are others. That requires building an IT solution to do that. It requires developing investigation capabilities. It also requires hiring, the commissioner was referenced earlier, and standing up the physical or organizational structure. And so it is a significant amount of work, and therefore a year is what we are estimating would be required to start the operation of the registry.
So if this bill does not receive royal assent, let's say we are looking at the fall, and the election must occur by a date in October of 2025. Move back a week, I might note, so that the leader of the NDP can get his pension.
Point of order.
On a point of
I've
order,
got great respect for Mr. Caputo, but if he wants to have a proper line of questioning without interruptions, he can probably just stay on the topic at hand.
Thank you.
When it comes to the timing of the election, and we do have issues with the timing of the election regardless of what mothers at this table may agree with or not agree with, we're looking at an October 2025 election. If this bill does not receive royal assent before we break, or at least we substantially have done the work, and we are into the fall, we could then be not even in a place to have this in place and functioning prior to the next election if it were to occur in the fall of 2025. Is that accurate?
Well, we're estimating about a year to put in place the registry and the commissioner in the office around it. We can look at how timelines could be accelerated. What I want to mention is that the SOIA new offenses and the amendments would come into force 60 days after royal assent, and that would be well in place for that timeline.
I'm sorry, could you repeat that last part, please?
I said the SOIA amendments and criminal code amendments will be in place 60 days after royal assent.
So the amendments will be in place, but I think what concerns people, me anyways, and the people around this table is there's no use in having a registry if what it is aimed to combat really can't be combated because we ran out of runway, which really does speak to Mr. Cooper's earlier points. I mean, we had Bill C-282 by a former colleague of this House, Mr. MP Kenny Chu at the time, who I think fairly clearly there was electoral interference that may have cost him his seat. And we could be running into that very thing, and that's of concern to me. Now, I'm going to ask a few other questions about the appointment of the Foreign Intelligence and Transparency Commissioner. That the appointment occurs through an order in council, is that correct?
That's right.
Okay. And at this point, there has to be consultation with the House and the Senate. Is that accurate?
That is correct.
Okay. Now, other officials, and I don't want to draw a parallel between the officials, but other such officials, sometimes there has to be some sort of approval by Parliament and the Senate as opposed to simple consultation, because consultation can be ignored. Would it strengthen the independence of the Foreign Influence and Transparency Commissioner if there was a requirement in the legislation to have formal approval by the House and the Senate?
That's your time, but witnesses may answer.
Amendments to the bill will be up to Parliament. I think the registry or the legislation proposes a number of elements that would make the commissioner independent in their decisions to pursue action, and those are built into the legislation.
Thank you. We go now to Mr. Jennis. 5 minutes, please.
Thank you, Chair. Winston Churchill apparently once quipped, you can always count on the Americans to do the right thing only after they've tried everything else. And in this case, the Liberal government has definitely tried everything else to avoid action on foreign interference over 9 years. But with C-70, they've finally responded to pressure from the opposition and from the public. Conservatives don't want to let the government get away with sitting on this bill. After 9 years, we've had enough delays. We will push for anti-interference measures to be passed and in place as soon as possible. Now, one important flashpoint for the foreign interference conversation is Hong Kong, because Hong Kong's national security law makes absurd claims of universal jurisdiction, even claiming that if a Canadian in Canada makes statements that are deemed to violate Hong Kong's national security law, they could be charged and even rendered to Hong Kong while traveling in a third country. The manager of Hong Kong's Economic and Trade Office in London has been charged with spying. I've heard concerns from the Canadian Hong Kong community about the activities of the ETO in Canada. Hong Kong is no longer meaningfully separate from the mainland, which raises questions about whether these offices have any legitimacy anyways. So is the government reviewing the activities of the ETO as they relate to foreign interference?
Mr. Chair, this would be a question that would be better addressed by Global Affairs Canada.
Okay, no officials have a response on that? Okay, I would welcome a response in writing if you're able to communicate with your counterparts, because I do think it's relevant to our work today. I have a specific question for CSIS about a personal example and information sharing. As you know, my personal email was targeted as a result of my involvement with the Interparliamentary Alliance on China. The Government of Canada did not have my back. They didn't tell me about this threat or how I could protect myself. I'm a vocal member of the opposition, often critical of the government, and the government didn't report the information to me in a way that would have helped me protect myself from foreign interference. The government didn't have my back, but our institutions should have. But unfortunately, CSIS did not have the legal authority to share information directly with me as per the current law. If the changes of this bill had been in place, using my experience as an example, would CSIS have had the authority and been able to simply communicate directly with me right away about these threats and what I could do about them?
I think there's a specific question about the incident itself, and clarity needs to be provided a little bit insofar as the service is not the lead for cybersecurity for the Government of Canada, and I think this issue is relevant to another committee study, so I won't address that specific fact. But on the broader question around information sharing, certainly the service has some significant limitations in the disclosure of information collected in its duties and functions with anyone outside the federal government beyond law enforcement effectively. And so with amendments in the Act, there would be a clear authority to engage outside the federal government for the purpose of building resiliency to threats. And that could be an early, preventative, proactive kind of disclosure of information informed by our investigations. Where information has a personal or private element, the minister would determine that information could be disclosed if it was in the public interest. I don't want to really speculate on a specific scenario such as this one with hindsight, but I do think this would improve our ability to engage.
I understand, but just to drill down. So if there was a threat to me as an opposition member of Parliament that you became aware of, it sounds like even after this bill is passed, you would need the minister's determination that telling me was in the public interest before you could tell me. You wouldn't have the discretion to say, Mr. Genis needs this information right away because it's relevant to his life.
I would correct that presumption. In fact, the service, if there were a manifest threat occurring under its threat reduction mandate today, it could disclose information for the purpose of reducing a threat when the threat is unfolding, active. The amendments in the bill do something different. They enable an earlier and broader engagement for the purpose of building resiliency to threats before the threat
with
is
ministerial
real.
consent, though, or not?
No.
No
ministerial consent required.
Okay.
But no disclosure of personal information.
Okay. That seems like a gap to me, but I'll go on to one more thing here. Just following my general skepticism about the government's will to address this, why the requirement of Attorney General consent, and what would happen in the case where the Attorney General might be in a conflict of interest, such as where the Attorney General might have personally benefited from foreign interference in his or her own riding?
Thank you for the question. The requirement of Attorney General consent already exists in the SOIA, and so the new offences which would be integrated into the SOIA would, that requirement would continue to apply. In general, the requirement of Attorney General consent applies to ensure that there is the proper assessment of the key elements of whether there's a reasonable prospect of conviction and the public interest in proceeding with a prosecution, that assessment is taken at an appropriate level given the context of the interests at stake. And in practice, in our system, that Attorney General consent is usually exercised by the Director of Public Prosecutions.
Thank you, Mr. Genis. We go now to Mr. Shipley for 5 minutes.
Thank you, Chair. And my first question, I'm going to build off of what a couple of my colleagues, Mr. Cooper and Mr. Caputo, were speaking about, and more really of time is of the essence with this bill. We are aware of the last few elections or more, there's been foreign interference situations with different electoral districts across Canada. So we know there's a looming election. We heard the date this morning, October 2025. That's not that far away. We've also then heard that it's going to take approximately a year to really implement and get this registry set up. My pre-political life, I was in the private business world, and in a year, you could incorporate a company, find a facility, bring in inventory, hire employees, get customers, ship, and start making profits in a lot shorter time than a year. Could maybe someone from each department please enlighten me how this implementing could possibly take close to a year or more?
Thank you, Chair, for.
Just for context, so the amendments to SOIA will be in force 60 days after royal assent and ceases. So that doesn't require the timeline. If we're creating a new regime, which is the commissioner, then there's some delay. So I just want to have a broader perspective on the bill. But no.
Thank you for that, Sebastien. The year estimate is based on the number of regulations that need to be brought forward and promulgated by the Governor and Council. It also requires actually setting up an office. While the proposal in the bill is to establish it within a department, it does require staffing up an office, for example, hiring a commissioner. We are going to be dealing with Canadians' private data in establishing the registry. That requires a privacy impact assessment to make sure that we're dealing with that data in a way that is appropriate and consistent with privacy laws. It also requires establishing an IT platform to receive information for the registry and then publish that information back out to the Canadian public so that they can consult the database. It will require developing guidance for Canadians in terms of expectations. For example, if we look over at our friends in the UK, the law came into or received royal assent last summer, 2023. They issued guidance in February of this year that is intended to educate people on their obligations with regard to the registry. The goal of the registry is to increase transparency, and one of the key ways of doing that is by clearly communicating to Canadians who might be in arrangements with foreign states. And because it is country agnostic, that encompasses every foreign state. What are their obligations in terms of registering? And so there's a significant part of this that is educating the Canadian public on their obligations. And building guidance in will make sure that people know what their obligations are. And so those are some of the steps that will need to be put in place so that we have a proper functioning registry when it gets launched.
Thank you for that. Is there anything specific this committee could do here today or in our meetings coming up that we could help anybody assist to speed this up at all? Is there anything specific we could do?
I think we're at your disposal. We will be here to support the work of the committee and answer your questions, and we'll stand ready at any point in time to support that work.
Okay, thank you for that, and hopefully it goes as quickly as possible. Speaking of the registry, there's been some concern that some foreign governments may be able to exploit diaspora communities by enlisting volunteers rather than paid agents, which may bypass the need to register in the foreign agent registry. Has that been thought of at all? Is that factual?
Yeah, so the registry does not require the payment. The legislation, the bill, does not require the payment of monies for an arrangement to be captured by the registration obligation. It can be an understanding of doing a favor or anything like that. It does not require payment.
Thank you. And has a charter statement been completed on this legislation?
Thank you, Chair, for your question. So, as is the normal practice, the Minister of Justice will be tabling a charter statement that will outline the potential implications of rights and freedoms protected under the Charter by Bill C-70. I don't believe it's been tabled yet, but as per the practice, that would be our expectation.
Thank you.
Thank you, Mr. Shipley. We go now to Mr. Cooper. Mr. Cooper, 5 minutes, please.
Thank you very much, Mr. Chair. Two of the public safety officials. The coming into force of the Foreign Influence Registry is subject to an issuance of an order in council by the Cabinet, correct?
That's right.
That's right.
And there is no date prescribed for when that order in council would be issued, is there?
That's correct.
So there is no date, correct? Okay. And so it would be correct to say that there's nothing in the legislation that would prevent the government from differing in issuing that order in council.
It is up to the Governor and Council to decide when that is.
Now, with respect to, so yes, and the answer is yes, there's nothing to prevent the government from differing.
Yes, it's up to them to decide when.
Okay, thank you. And there's much that has been left to regulation, including with respect to administrative penalties as well as the contents of what must be disclosed to the commissioner. So once the bill passes, assuming that it does, I think it will, is there going to be another lengthy consultation process for what should be included in the regulations? We have seen that with respect to other bills that have been introduced and passed that have been delayed in terms of implementation because of another extensive consultation process. So is that in the works?
Thank you for, well, I don't know if you want to answer
No, I
first.
just want to say that I sort of disagree with your premise. I think this bill, FIDA, doesn't leave a whole lot left to regulations. A lot is in the statutes. And so the regulatory framework will be quite contained if you look at comparative other pieces of legislation. But in terms of the process, Richard.
Thank you. And some of them are simpler than others, determining the amount of penalties that corporations or might have to pay in terms of an administrative monetary penalty, or individuals. Sometimes there's a different initiation in regime, so that's fairly straightforward. But to answer your question about consultation, some of them might require consultation more than others. Some of them are very technical, but that is something, for example, if we were to consider adding classes of exemptions or another exemption to the regime, you can imagine that would require consultation.
I anticipate that there would be some sort of consultation process that could potentially take some time because certain aspects of it may be more complex than others.
It is possible that there will be some consultation activities on some
Okay, so I think this just underscores that we have more delay and underscores why time is of the essence, and it just underscores that this should never have, we should never have been here, and the reason we are here is because this government failed to act, failed to move forward with establishing a foreign influence registry year after the consultation process has ended, and only now are we beginning to study a bill that is, as of yesterday, the first day of debate at second reading stage. Moving on to the foreign influence registry provisions, specifically the definition of public office holders, I would note that, for instance, appointees of the federal cabinet constitute a public office holder, but provincial cabinet appointees of provincial cabinets are not included. Similarly, officers, directors, and employees of federal boards, commissions, and tribunals constitute a public office holder, but the same would not seem to apply with respect to directors or employees of provincial or municipal government corporations or agencies. So why were those left out?
So thank you, Chair, for the question. I would point out that the legislation provides that it would apply to provincial territorial governments when that is brought into force. Same thing with Indigenous governments. They would apply to them when that is brought into force.
I understand that, but and it applies to federal government as well, but I cited two specific sections in terms of what constitute public office holders. There appears to be a gap there. I want clarity as to whether I'm correct in that interpretation, and if I am, why were those left out?
I'd have to go back and look at the language of the provisions. I would say that the legislation allows, through the regulation, of adding classes of people. And if we became aware that there were a class of people that needed to be captured, it can be done.
Well, very simply,
Thank you, Mr.
appointees of
Cooper.
the federal cabinet, but
Thank you,
not
Mr.
appointees
Cooper.
of provincial government.
Thank you, Mr. Cooper.
So that would be part of the conversation. The reason we brought into force, or separately, the provincial and territorial components was to ensure collaboration with our provincial and territorial colleagues, so we could do that in an orderly way, considering that, and that can be part of those conversations. And I'm not saying it won't be. I'm just saying it's not right now.
So more
we're not
delay.
there.
Thank you, Mr. Cooper. That's enough. Having said that, I will now go to Mr. Caputo for 5 minutes, please.
Thank you, Chair. And Mr. Biddle pointed out that I was incorrect during my last round, so I should correct the record that the NDP leader's pension will vest prior to that date. It was 25% of his caucus that I should have been referring to. Now, in any event, when we're talking about sabotage and the sabotage-related offenses, we are speaking about infrastructure and critical infrastructure. So the question I have is this. I'm going to see if I can find the exact wording of the provision where it talks about essential infrastructure and the definition of that essential infrastructure. My question is whether we're talking about, for instance, under section 52.1 sub 2, transportation infrastructure, information and communication technology infrastructure, et cetera. We have, it looks like 8 or 9 enumerated grounds. 8 enumerated grounds, and then the regulations can add other infrastructure. So would the offense of sabotage apply only to infrastructure that has actually completed, as in other words, like an existing rail line or existing telecommunications line? Or what about when a private company or the government is in the process of planning or constructing that infrastructure? Would the offense of sabotage apply to that as well?
Thanks for your question. What I would draw your attention to is the definition of essential infrastructure in the bill. And what it says is that it means a facility or system, whether public or private, that provides or distributes services that are essential. So I think it would be a question of the specific facts and the operational state of that infrastructure. In theory, something that is still under construction is not actually at that point providing or distributing what we've defined as essential infrastructure here. Obviously, interference with that type of thing may be covered under other offenses in the code, but may not necessarily fall within the offense of sabotage related to essential infrastructure as in the bill.
Okay, that's interesting. I mean, to me, that's a bit of a gap because foreign interference could certainly seek to undermine that which is being built in Canada for infrastructure. So that might be an area that that should be considered for amendment. One of the questions I have is in relation to the offense of sabotage as well. The offense has a 5-year maximum, and this to me feels like a fairly serious offense. Is there a reason why this isn't a higher maximum for sentence?
Just to correct, it's a maximum 10-year sentence for sabotage when committed by way of indictment.
Oh, okay. I'm sorry. I thought it went from 2 years to 5 years, but I must have misread that. I apologize. Yeah. Okay, thank you. I believe Mr. Jennis is really chomping at the bit here to get in a last couple of questions, so I'll cede my time to him.
Always. Thank you, Mr. Caputo. One gap in terms of the response here has been around people facing coordinated discrimination based on political activity, people in diaspora communities who are involved in pro-democracy activity, for example, who then face various forms of discrimination that may be officially or unofficially coordinated from abroad. One instance I heard of recently, for instance, was someone involved in pro-democracy activism in terms of Hong Kong who faced negative consequences from their landlord as a result of it. Now, I have a private member's bill, C-257, that would add political belief and activity as prohibited grounds of discrimination, which I think is one solution. That wouldn't apply in provincial jurisdiction, but it would apply in federal jurisdiction. You can imagine similar models being adopted provincially. But I think this is one problem that Bill C-70 does not solve. I'd be curious for your feedback, especially the justice officials' feedback on this, and what steps could be taken to protect people from discrimination that may be coordinated from abroad and may respond to political activities that they're involved in here in Canada.
Thanks for the question, Chair. I'll save your remarks, and if my colleague has more to supplement, he can. I will admit I'm not familiar with your private member's bill, but I'm going to guess based on how you've described it that what you're talking about is adding political belief to the Canadian Human Rights Act. Is that correct?
Exactly.
Okay. So the Canadian Human Rights Act is a little bit different in the sense that it applies as between relationships between private individuals and discrimination that may take place there. So the stuff that we have in the bill would not cover those scenarios unless there is a link to a foreign entity, if that makes sense.
Okay, so if there's a link to a foreign entity, would it be covered if a foreign entity was, if the person who was doing the discriminating was involved or connected to a foreign entity in some ways, but that was in a private relationship? Would the bill impact that, and how?
That's your time. Witness may answer.
So maybe just to clarify terms, so discrimination normally is how you provide goods and services in the sense of the Canadian Human Rights Act, right? So I think my colleague can supplement, but I think what could potentially apply here is, for example, if you are doing something as the landlord at the direction, benefit in association with the foreign entity, that could potentially be covered by the new general foreign interference offense.
Thank you.
Thank you.
Sorry.
Just briefly, if the form of the discrimination rises to intimidation, threats, violence, or coercive behavior that doesn't give the victim a choice in the matter, then certainly the new and newly amended offenses in Section 20.1, 20.2 could apply to those circumstances. Thank you.
Thank you.